Mr. President, I rise today to speak on the latest efforts to to derail the nomination of Judge Brett Kavanaugh to be Associate Justice of the United States Supreme Court. I'd like to focus today on a few areas where attacks have come up. Judge Kavanaugh's critics, faced with an exceptionally well-qualified, baseball-loving, carpool-driving nominee, are struggling to find anything that might slow or even stop his confirmation. Let me focus today on a few areas where their attacks have come up short. It seems that some folks can't mention Judge Kavanaugh without suggesting in the same breath that his confirmation would somehow be the death knell of Special Counsel Mueller's investigation. It can be difficult to keep straight critics' dizzying array of claims on these separation of powers issues, but it's worth taking a closer look to set the record straight. It was hard to miss the headline. Brett Kavanaugh once argued that a sitting president is above the law, or the article that suggested Judge Kavanaugh has been an open advocate for precisely the sort of imperial presidency that the founders of the American experiment feared, unquote. Democrats soon piled on, but nowhere in the Law Review article that spurned this hysteria did Judge Kavanaugh suggest that a president would be immune from civil or criminal liability. Rather, he suggested that as a policy matter, it might be wise for Congress to enact a law that would defer such litigation until the president leaves office. And of course, Congress could accelerate that timeline through impeachment. Judge Kavanaugh's Law Review article represents an interesting policy proposal, and one, it's worth noting, that he offered while a Democrat was in the White House. But critics' attempts to equate his policy recommendations with his views on the constitutional limitations on prosecutions of sitting presidents are simply wrong. If anything, Judge Kavanaugh's recommendation that Congress enact a law suggests that, in the absence of any such legislation, a sitting president can be investigated and perhaps even prosecuted. Then there was the hoopla over Judge Kavanaugh's statement that he would, quote, put the final nail, unquote, in the ruling that upheld the constitutionality of independent counsels. Never mind the fact that the independent counsel statute expired nearly 2 decades ago and was described by Eric Holder as, quote, too flawed to be renewed, unquote. Today, special counsels like Robert Mueller are appointed pursuant to Department of Justice regulations that do not represent the same constitutional concerns as the independent counsel statute. By conflating independent counsels and special counsels, Judge Kavanaugh's critics ignore his own record on the matter. In a dissenting opinion he wrote last year, Judge Kavanaugh himself observed, quote, the independent counsel is, of course, distinct from the traditional special counsels who are appointed by the Attorney General for particular matters, unquote. But Democrats just figure that the average American will gloss over the distinction between independent counsels and special counsels and tune out legal experts who say Judge Kavanaugh's views on the independent counsel law have absolutely nothing to do with the Mueller investigation. And by the time we're on to them, Democrats will have already moved on to a new line of attack. The latest was the minority leader's suggestion that Judge Kavanaugh, quote, would have let Nixon off the hook, unquote, based on comments that Judge Kavanaugh once made about the Supreme Court's unanimous decision in the United States v. Nixon that forced President Nixon to turn over the Watergate tapes. But those comments, read by some to suggest that Judge Kavanaugh thinks the case was wrongly decided, ignores the context of those specific remarks and the mountain of evidence that Judge Kavanaugh agrees with the court's ruling in Nixon. There's the law review article in which Judge Kavanaugh wrote that there was, quote, no need to revisit, unquote, Nixon, and that the case, quote, reflects the proper balance of the president's need for confidentiality and the government's interest in obtaining all relevant evidence for criminal proceedings, unquote. More recently, he has cited Nixon as one of, quote, the greatest moments in American judicial history when judges stood up to the other branches, were not cowed, and enforced the law, unquote. Those sure don't sound like the words of a judge who is critical of the court's decision in Nixon, much less a judge who would vote to overrule it. But this more fulsome look at Judge Kavanaugh's writings on the issue is at odds with the Democrats' campaign to paint Judge Kavanaugh as an existential threat to the Mueller investigation. So they're content to cherry pick and mischaracterize Judge Kavanaugh's record. On the subject of Judge Kavanaugh's record, I would also like to talk about Democrats' fixation on the issue of Judge Kavanaugh's documents from his years of service in the executive branch. It's only been 2 weeks since President Trump nominated Judge Kavanaugh, and yet Democrats seem more interested in using their time talking about documents they do not yet have, rather than carefully reviewing the unprecedented number of documents that are already available to the Senate and the American public. Specifically, we aren't hearing much from Democrats about the more than 300 opinions Judge Kavanaugh has authored during his time on the Circuit Court of Appeals for the District of Columbia. In these opinions, Judge Kavanaugh has addressed a vast array of hot-button issues Democrats claim to be so interested in: separation of powers, administrative law, national security, religious liberty, immigration, and so many more. Something Judge Kavanaugh told me when I met with him recently really stuck with me. He told me that he hoped people would actually read his opinions, not just articles about his opinions, but actually read the opinions themselves. So I would urge my Senate colleagues to indulge Judge Kavanaugh on this point. These opinions are gold for any senator making an honest effort to evaluate Judge Kavanaugh's judicial philosophy. Judge Kavanaugh has spent the past 12 years in public service and as a federal appellate judge. And now he has been nominated to be, you guessed it, a federal appellate judge. I can think of no better evidence of Judge Kavanaugh's judicial philosophy or his qualifications to serve on our nation's highest court than the thousands of pages of opinions he authored during his time on what is arguably our nation's second highest court. If Democrats actually took the time to follow Judge Kavanaugh's advice and read his opinions, not just articles about them or summaries prepared by staff, they might be disappointed to learn that there is nothing to suggest that people will die if he is confirmed. And they might actually learn how Judge Kavanaugh interprets the Constitution and the laws passed by Congress. Isn't that what all this commotion is about? It's about documents. Isn't that really what it's about? Now, I would suggest that Judge Kavanaugh's opinion should be more than enough to assess his qualifications and judicial temperament, not to mention the thousands of pages from his time in the executive branch that are already publicly available. And I understand that this represents just a fraction of the documents that the Senate will ultimately receive, likely to be far more than those received for any other Supreme Court nominee in history. Senator Grassley has pledged that relevant records will be made available through a fair and thorough process. But for some, it's never enough. We've heard Democrats claim they are not demanding every scrap of paper that crossed Judge Kavanaugh's White House desk, They have also said that the standard for determining what is relevant and subject to production should be whatever senators, in other words, Democrats, think is relevant. And some have even claimed that all the documents are, quote, extremely relevant, unquote. Well, if Democrats think the standard for document production should be whatever senators think is relevant, and they think everything is relevant, then it sure sounds like they're asking for every scrap of paper. Now, it is true the Republicans sought White House documents for Justice Kagan's nomination, but these two nominations, Kagan and Kavanaugh, are hardly comparable. At the time of her nomination, Justice Kagan had no judicial record to speak of whatsoever. Having never served as a judge at any level, she had no written opinions. There was almost nothing we could use to assess her judicial philosophy. The White House record was among the very limited information we had to gauge her fitness to serve, so of course we asked to see it. By contrast, Judge Kavanaugh has 12 years of experience on the Circuit Court of Appeals for the District of Columbia, the second highest court in this country. And that's not even to mention over 300 opinions. Again, thousands of pages have been written clearly outlining Judge Kavanaugh's views on the Constitution. If Judge Kavanaugh's extensive record is not enough to paint a clear picture of his judicial philosophy, then what is? What more do Democrats need to know? That this is a man who is eminently qualified to serve on our nation's highest court. I can only think of one reason why a senator would need every scrap of paper to evaluate the qualifications of a judicial nominee, any nominee for that matter. And that is if they're going on a never-ending fishing expedition, which is clearly what the Democrats have been doing since the day Judge Kavanaugh's nomination was announced. I would urge my colleagues to follow Judge Kavanaugh's advice. Read his opinions. You undoubtedly will learn something about how Judge Kavanaugh interprets the Constitution and the laws passed by Congress. Then by all means, continue your fishing expedition, but at least you will have consulted the record that matters the most.